These are applications and appeals on matters of Cinven, Competition Manager, and General Partner Limited, and others, and Competition and Markets Authority.
My Lord. My Lords. As you, my Lords, probably know, I appear on behalf of Advanz. Mr. O'Donoghue to my right and Mr. Raymond behind him appears for Cinven. Mr. Raymond will be dealing with the penalty aspect of Cinven. And then Mr. Holmes to my left appears for the CMA with Professor Bailey and Miss MacLeod. And as I understand it, Professor Bailey will be dealing with the penalty in response to Mr. Raymond. The court will have a list of issues that is in the core bundle at tab 1, page 3. From this document, there are 3 main issues: the proper interpretation of unfair pricing, and then there's various aspects to that. Then issue 2, acquiescence; issue 3, penalty. Obviously, we've put all the submissions in writing.
Yep.
And what I would like to do, I'm going to concentrate on the regulatory framework and the entry incentivizing price. As I go along, I will touch on portfolio pricing and acquiescence. And then Mr. O'Donoghue is primarily concerned with the post-entry price. So I'm primarily concerned with the regulatory framework, entry incentivizing price, and Mr. O'Donoghue will deal with the post-entry price and a couple of other points. And he's kindly given me 2.5 hours.
Very generous.
I know. So without further ado, could I...
Can you just give us an indication of how you divided up the time?
Well,
so you're taking 2.5 hours.
It's almost equally. So equally CMA and the appellants, and it's equally between Mr. O'Donoghue and myself.
And that deals with your appeals applications, and then we've got the penalties applications, which are half a day in total.
Yes. Yeah. So I might get a little bit of indulgence because I'm not dealing with the penalty because of the statutory cap, but it's broadly a quarter, half. So without further ado, if I could start with the regulatory context, which is obviously important because the pharmaceutical industry is highly regulated. And I just want to go to start with 2 documents, and they're in the authorities bundle. And that's volume 1 of the authorities bundle. So we can put the issues away. And it's authorities bundle tab 7 first.
Can you give me the page number as well?
Oh, I beg your pardon, yes. Page 49. So tab 7, page 49. And this is the old National Health Service Act 2006. It's been amended, but this was in force during the relevant time. And section 262 gives the Secretary of State power to control prices. The Secretary of State may, after consultation with the industry body, limit any price which may be charged by any manufacturer or supplier for the supply of any health service medicine. And then that's paragraph 262(1). And then 2, if at any time a health service medicine is covered by a voluntary scheme applying to its manufacturer or supplier, the powers conferred by this section may not be exercised at that time in relation to that manufacturer or supplier as regards that medicine. It's been amended, but the section 262 granted the power to the Secretary of State to limit any price, and at the time, if there was a voluntary scheme, then the Secretary of State wouldn't exercise that power. So you had the power, if there were, and the 2 schemes, as my lords will know, there's the PPRS, which applies to branded, and Scheme M, which applies to generics. And it's to Scheme M I'm going to turn to, and that's at tab 8 at page 50. So scheme M, which is, you see this at page 50, it's revised long-term arrangements for reimbursement of generic medicines. There was a previous one, this is March 2010. We see at page 51, the scheme is a voluntary, non-contractual one made by the Secretary of State and the representative body, and that's the British Generic Manufacturers Association, within the meaning of Section 261 of the National Health Service Act 2006. So this is a voluntary, non-contractual scheme envisaged by the 2006 Act. And I just want to emphasise some paragraphs from this statutory scheme. So paragraph 1 has an introduction, and I'll call it the Department of Health. It's changed its name, but if I call it the DOH, the Department of Health and the generic pharmaceutical industry have a common interest in ensuring that, and I'd like my Lords to see, ensuring that safe and effective generic medicines are available to the NHS via a resilient supply chain that provides a reasonable return for all those involved. So I emphasise safe and effective generic medicines and a resilient supply chain. And then we see objectives. The objectives of the scheme are that it should maintain and, where possible, improve the quality of service to patients in the community, maintaining a secure and reliable service which meets clinical need. So again, the Department of Health wants a secure and reliable service that meets a clinical need. Achieves transparency in the market. We see the third bullet, which is not unimportant for this case, promote a competitive pharmaceutical market, secure value for money for the NHS. So there's not a hint at the moment of there being a cost plus approach, promoting competitive pharmaceutical market, securing value for money. Obviously, the court can see that the bullet points.
Sorry, did you say? Sorry, we're going to get a transcript, I'm sure.
Yes.
I hope. And I'm sorry, I have some competition out there from somebody. Did you say there was no hint of a cost plus? Is that what?
Yes, so no hint of a cost plus. We shall see the reasonableness of the prices, but there is an objective to secure value for money at reasonable prices. But what the Department of Health also, and this is a big point that I'm going to make this morning, it wants medicines that meet a clinical need.
Right.
And
how do you, if you say there's no hint of a cost plus, how do you interpret the words "provide a reasonable return"? Does that exclude cost plus?
Well, it depends what a reasonable return is.
Right.
Yes. So it's. But that's.
Well, you said there's no hint of a cost plus. I mean, obviously there's no words cost plus, but you skipped over the words providing a reasonable return. That could include cost plus, couldn't it?
Well, it certainly could, and I don't want to shy away from that, because if one goes to paragraph 31, I'll go out of, one goes to paragraph 31 at page 57. And it's a reasonable return for everybody, but so paragraph 30, this is why I say this. The paragraph 30 and 31, we do not see here a hint of a cost plus approach, which is taking some very small direct costs to the specific product, indirect costs to the specific, and then a reasonable return on that specific product. What we see, paragraph 30, is wherever the department will allow, well, sorry, could I go back to, I beg your pardon, to paragraph 27 before we get to 30. So pricing and submission of information, this is at page 56. The scheme allows freedom of pricing subject to the following provisions. This is paragraph 27. Any scheme member supplying a generic medicine to the NHS may set or alter the price at which that medicine is sold to wholesalers or dispensing contractors without any prior requirement to discuss such prices with the Department of Health. So I do maintain the point that there is freedom of pricing. We do not see here the sort of cost plus in the decision, which is you take specific costs to the specific product and then have a reasonable return on those specific costs. This freedom is allowed on condition that if requested to do so, a scheme member shall provide the Department of Health with information sufficient to satisfy the Department of the reasonableness of the prices. See paragraphs 30 to 34. And then, if one goes to 30 and 34, wherever possible, the Department will allow changes in market prices to be influenced by existing market mechanisms. So it refers to essentially freedom of pricing and changes in market prices. This means that where there is effective competition in respect of any given generic medicine, then the Department will not interfere in the operation of the market for that medicine. So, prima facie is looking at market prices. However, should the Department identify any significant events or trends in expenditure that indicate the normal market mechanism has failed to protect the NHS from significant increases in expenditure, then the Department may intervene to ensure the NHS pays a reasonable price for the medicine concerned. And then to allow the consideration of prices and reimbursement, the scheme member shall provide to the Department on reasonable request an analysis of the direct and indirect manufacturing and or supply costs of the product or products which have increased in price, and then supported by available evidence such as invoices. And that's the first bullet. And then the second bullet, the Department may also require a company to show that their profit margins on sales of other products are fair and reasonable to the NHS. So it is looking at the specific costs in bullet 1, but it's also looking at portfolio pricing in bullet 2. But it is not mandating, and I appreciate this is not an exemption from the Chapter 2 prohibition or Section 18. It's not an exemption, but it is mandating, where possible, market pricing, promotion of competition, securing value for money for the NHS. And this is the important point for this morning. Value for money, medicines which are safe and effective, and a resilient supply chain. Because as we shall see, the Department of Health wants a resilient supply chain because it doesn't want shortages. And in a nutshell, we say that the decision loses sight of these objectives. It goes to a very low cost plus and jettisons the improvements in safe and effective generic medicines, and it jettisons the notion of a resilient supply chain. Now, as I say, we obviously submit that this, this scheme does not exempt Advanz from the competition rules. That's obvious. But it is important to the fairness of a price from the perspective of the Department of Health. The Department of Health is the ultimate customer because it pays the price of the drug. And Scheme M is important because it shows what the Department of Health values, what it is seeking from the suppliers, what it is paying for in return. So as I say, the Department of Health wants to secure value for money for the NHS. That's the key objective. But it wants a reliable supply of medicines to ensure there's no shortages. It wants to pay for medicines that meet, and we shall see this time and time again, to meet a clinical need. And just so I can finish on the scheme,
Just before you do that, you mentioned that the second bullet point in paragraph 31 might have relevance to portfolio prices.
Yes.
Could you just explain that a little bit more? That provides for the company to provide information on other products.
Yes.
What relevance does that have in relation to portfolio pricing?
Well, so the department may also require the company to show that their profit margins on sales on other are fair and reasonable. So it may well be that the department says, well, under the first bullet, you're making quite a return, but then the supplier will say, well, I'm actually giving you a massive discount on these following 3 products, and it all equals itself out. So we know from the PPRS, the branded scheme, that the department looks at the portfolio of prices. And the evidence we refer to in our submissions, and we'll come on to that in part, but the evidence is that the Department of Health will also look at a more holistic approach to pricing when it comes to generics as well.
Is this the only reference to portfolio pricing in Scheme M?
Yes, it is. Yeah, I mean it's hidden away, but it is still there. In order to determine the reasonableness of the company's prices, that's the big heading. It will look at the specific costs, but it will look on the returns on sales of other products. And Mr. Williams, who is one of the witnesses in the case, he looked at Advanz's returns across the board and said they were quite within the permissible limits as a whole, even though the price of Liothyronine had gone up.
Can I just get my bearings so I know where we're headed? You said that one of your criticisms of the decision was that it went straight to low cost plus and jettisons the consideration of maintaining a resilient supply chain.
Yes.
So was there evidence that the increase of prices that were put in place here was necessary in order to sustain a resilient supply chain? Are you going to show us some evidence?
I'm going to show you. Yes, I will show you some evidence. Yes.
Okay.
Yeah. What the tribunal said, that you don't see any bright line point from the department saying, I hereby approve this price increase in Liothyronine to...
No, I was just wondering whether your clients who put in place the increases in the price of this drug had any evidence that they did so in order so they could maintain their supply chain.
Absolutely, yes, they did. There was evidence from Mr. Baton and the General Counsel, Mr. Sully.
And what are you saying that was evidence which it was irrational for the tribunal to disregard, or are you just saying that they didn't place enough weight on it? Or
the answer to that is that they didn't place enough or any weight to it, so it was irrational, both on the part of the CMA and on the part of the tribunal. Yes, we will come on to this, but it was a large criticism of Advanz at the hearing below, that in a 1,000-page decision which imposes quasi-criminal penalties, the balancing of the price of £40 to £60, which is our market. All I'm talking about this morning is the market incentivising price of between £40 and £60. I'm not looking at the £250 that was applied in 2017. My submissions this morning are purely and simply about whether the market incentivising price, which led to Teva and Morningside entering the market, bringing improved medicines and security of supply, was worth it. So I'm looking at the price of 40 to 60, and the decision basically ignores it. It puts it in a footnote. And that's a large criticism that we made below, and I want to repeat this morning. Can I then, before I get on to that evidence then, just finish off Scheme M. We go back to paragraph 4 about membership. And Advanz was a member. Paragraph 13, although this is not a contractual document, paragraph 13 says the scheme can't be unilaterally amended. So it does mean something. And then 14 and 42, so paragraph 14 and 42 refer to compliance with the scheme. And so 14, any company that fails to comply with the scheme or fails to provide information in any way acts in a manner that would breach the scheme will be required to leave the scheme. That company shall then not be exempt from the terms of any relevant statutory scheme. You get excluded from the scheme, then the powers under the Act we saw would come into play.
So that's 2621.
Yes.
Secretary of State's power to limit price.
Can I just give you an example of that? Unless there's any questions on Scheme M, I propose to put that away. But we say it is relevant because it is relevant to what the Department of Health wants from the industry. It's not just about medicines at the lowest possible cost, which is so. I can put that away. Now we have an unagreed bundle, which I want to refer to this morning. I don't know whether there's any objections to it.
I mean, my main objection to it is that my bundles are in a pretty dodgy state. So I think if you're going to go to an unagreed bundle, if you can, I've also got some pages missing, I think, from at least some of it.
Okay.
How many unagreed bundles do you actually have?
One.
One.
How many pages is it?
Well, I've got two, rather worryingly.
Well, maybe that's just been put saved, but I don't know. Mine. I have an unagreed bundle that goes.
Two agreed, one unagreed.
I've got
Unagreed.
I've got two agreed.
Yes.
I've got two unagreed, with some pages missing in the middle.
Well, I'm very sorry for that, and if we can assist
Well,
at lunchtime, but hopefully I won't
Can we
be
just
referring
check?
to them.
Can I just check? The unagreed bundle you're about to go to has, is it 33 tabs, is that right?
Yeah, 33 tabs, yes.
And
Goes to mine goes to 491. I think Mr. O'Donoghue wanted to put the whole of the joint expert report.
yeah, okay. What was missing from mine, just in case anybody else also labours under the same disadvantage, is my first bundle stopped at page 383, and my second bundle kicked off again at page 398.
Right.
And so I'm only just saying that I discovered that. That may just be peculiar to me, but it may be that the other members of the panel have the similar disadvantage.
My unagreed bundle ends at tab 27.
Well, for once, I'm ahead of the game.
Well,
We also on the. I mean, since we're having a whinge fest, let's get it on.
yes.
The other problem we have is that on the back of the bundles, it doesn't tell you what's in them. It just says call, authorities. So we've got no idea. I mean, if this happens, we tend to just shove them back on here. I have no idea whether it's volume 1, 2, 3, or 4. So I'm afraid we're going to take quite a bit of time finding whatever it is you want.
I'm sorry. Yeah.
Well, you know, not your fault.
I will just say the quality of the bundles is good in terms of actual resilience to being dropped. They're very nice. So that's an advantage.
That's a plus point.
I remember
When
Mr.
we're
Justice Laddie
balancing.
throwing them because it didn't have the kind of this bit on it. Hopefully,
Well, you will try and find
Yeah.
whatever it is.
Okay. So let's let's try this one. Can I try tab 19?
Yeah, you're safe with that.
Well, we'll see.
So all I want to do here is show how this just to identify this is nothing to do with this case in the sense of Liothyronine. So this is, sorry, I beg your pardon, it's page 330.
Sorry, page 330.
330.
Right, yes.
But there have been other excessive pricing cases, and this relates to the phenytoin case. And if one goes to page 333, this is in June 2013, and it was an information request from the OFT at that point. This is about the pricing of phenytoin. And
Can I this is a separate case. I mean,
This is a separate case.
Is there authority and consent to use this document? It seems to be unrelated to any of the parties. Or should I simply not ask that question?
I would hope, I would ask.
My lord, it was disclosed in these proceedings, so I think it's safe to consider it.
So all I want to refer this document is we saw there's provision in Scheme M to expel companies if they are not behaving.
Yeah.
And the question is asked on 332 to a person called, well, I'm not...
This is the middle email, is it? The 28th?
It is, I have specifically sent you. So this is to...
This is 1146, middle of the page.
Yes, and
Yeah.
it's to that person, that man, is if one looks at 331, you see the name on the top
Yes.
left,
Yes.
and that's Mr.
Oh, right, okay.
Mr. OG, and the answer is yes.
Okay. Okay, that rings a bell.
Yes, and the only thing I just want to refer to is that so the price of phenytoin went up.
Yeah.
The department was concerned about it.
Yeah.
Called the company Teva in.
Yeah.
And Mr. Baton was a director of Teva at the time.
Yes.
And we see at the bottom the Mr. OG is replying, saying the distortion was an irritation, and to the meeting with Teva, it was agreed to reduce the reimbursement price over a period of 7 quarters. The alternative of ejecting the company from membership of Scheme M and then enforcing a maximum price by direction of the Secretary of State was considered a less attractive option.
Yeah.
So that was threatened. Actually, the meeting was in 2007. So he's going back some time. That was Mr. Baton who gave evidence because he'd moved from Teva. Mm-hmm. And then if one just goes to tab 21 of page 338, this is July 2013. We have the same players from the Department of Health. We see there Mr. Baton, he is now at Advanz. This is not to do with Scheme M, but the PPS.
Sorry, give me the page reference again.
Oh, I beg your pardon, page 338, tab 21. And all I'm doing is this is a meeting, so AMCO, that's Advanz, has been called in. This is not to do with generics, but to do with branding issues. And at paragraph 2, in its opening remarks, the Department of Health made clear it considered that AMCO affiliates what it termed high maintenance in respect of PPR membership. It was considering whether the scheme was not effective in AMCO's case, in which case the Secretary of State would eject the company and would fall under the statutory scheme. And I just mention these two documents because there is not an issue in front of this court about countervailing buyer power, but it is important to see from a regulatory context that Scheme M is there, you can be ejected from Scheme M, and the Secretary of State can impose maximum prices. And the industry, and this is important, the industry perceive that, and we can see that from these two.
I'm just trying to, again,
Yes.
just understand. What does high maintenance, in inverted commas, mean?
Well,
Why your clients high maintenance?
I would suggest not. I think if one looks at paragraph 21, that is just a comment.
Sorry, you took us to paragraph 2.
Well, I'm taking it not so that AMCO is high maintenance. I'm taking the court to show that the Department of Health thought it was high maintenance and was threatening to reject it from the scheme.
Yeah, because
If one looks at the discussion at paragraph 3, Department have noted that there were several issues outstanding with the PPRS business, and a lot of it's redacted. And then in the summary at paragraph 10, you get some agreement. So I don't believe that this document shows they're high maintenance. There were clearly issues.
it shows that the Department of Health thought they were.
Yeah, well, but whether that is true or not is another matter. Certainly, the issues were agreed, and they didn't go to dispute resolution. But the department was threatening to eject them from the scheme, and it is quite clear that this is why it's not just about a cost plus price. The department does have the power to control prices if it wants to, whether informally by threatening expulsion from the scheme. But can I move on to the more important point, which my lord you've asked me, which is about the entry incentivising pricing and the benefits of new entry. So I want to finish with a regulatory setup, and I want to move to the next main topic, which is entry incentivising price. And we saw that on the list of issues. And we say that there was a range of a market incentivising price here of around £45 to £60. So we're not talking about the big ticket items in 2017. We're talking about prices in force in 2012/2013. And we'll see this in a moment. 2012, 2013, when the prices were around £45 to £60. And these prices stimulated new entry, and the new entry brought improvements, which we say the decision does not properly address, and nor does the tribunal. And I'd like to deal with this issue of entry incentivising price under three main headings. First, the level.
And I just in terms of the range, if I remember rightly, the CMA thought the entry incentivising price was about 21 quid, if it was relevant at all.
Tribunal thought that.
And the tribunal, that's just
Yeah. I'll come on to it, but basically, Morningside, the price, when Advanz's price was £45,
yeah.
that stimulated the entry of Morningside. And the CMA said that would be that was a market incentivising price. You then had a second player come into the market called Teva. Now, there was a dispute about what price incentivised Teva, and we say it's around £60. And that brought in a second new entry. What my lord is referring to is what the tribunal said. Well, there was another player, Unifarmer, who also looked at entering earlier when the price was £20, but it never entered. It decided the economics were not there, but it just did not enter. And we say that is not a market incentivising price if the relevant player doesn't enter. And there was an issue of that, and we addressed that in our skeleton. So that £20 we say is a red herring. It never stimulated new entry. If a market incentivising price is going to be relevant at all, as we'll see in NAP, one is looking at successful market entry. But under three main headings, I want to look at the level of the market incentivising price, the benefits of new entry, which are the security of supply and the improvements in Liothyronine, And then lastly, before lunch, I want to go through why the tribunal was...
Could you move the microphone closer to you? Because I think I'm afraid the transcriber's struggling to pick you up.
Why the tribunal was wrong to reject the market incentivizing price. So I want to look at the level first, second the benefits, and third why the tribunal was wrong. So if we go to the first topic, which is the level, we go to the decision first. That is at the core bundle 2, page 511. Core bundle 2, page 511. And this paragraph 4142 at page 511 is the passage in the decision which refers to the market incentivizing prices. So 4142, the CMA says, consistent with Advanz's own view that entry was not attractive, there is no evidence of interest from potential competitors in entering the market until that of Unifarmer in 2010, whose efforts were discontinued in 2013, so that wasn't a market incentivizing price. Then the CMA goes, the first successful entry attempts did not begin until 2012, Morningside, and 2014, Teva. The evidence indicates that these entry attempts were stimulated by Advanz's pricing behaviour, which increased the market size by sales value, with the result that entry became increasingly attractive in terms of the potential revenues they could earn. And so, as is very common in the generics industry, the prices were a signal to new market entry. So those are the market entrants, the successful ones, Morningside in 2012 and Teva in 2014. And if one then goes to the judgments, it's the best place to find it, where we see the prices set out. So that there is a table 2 in the judgment at paragraph 85. That's the judgment 216. We can put the decision away, I think, for the moment. The judgment has at paragraph 85, page 216, a handy table which looks at the cost plus and compares it to the prices that were charged.
And these are the ASPs, average selling prices?
Yes, the ASPs.
Yeah.
And so in 2012, the CMA accepts that 45.52 was a market incentivizing price.
Sorry, in 2012,
2012, as we saw that Morningside entered, well, it didn't enter, it entered some years later, but in 2012, it decided to enter, was successful at 45.52. Mm-hmm. In 2014, this is an average, it had gone up to £94. But we deal with this in our skeleton at paragraph 30, and we say, well, we will take, essentially, to stimulate Teva, the price at £62, at 61.84, because that would have continued into 2014. And 2014 was just an average. And so we're being conservative in the sense that we're taking the minimum of 45.52, but we're taking a slightly higher price, which was in place at the end of 2013, beginning of 2014, which was in the 60s. And we submit that is a reasonable range, and that we give various reasons at paragraph 30 of the skeleton as to why that is a reasonable range, because that range incentivises two successful entrants. And what is not a market incentivising price is the CMA's cost plus price. And for that, one can go to the judgment which is in the core bundle at 302. And the relevant paragraph is 324.
This is the
judgment
of the judgment.
Page 302, paragraph 324. So there is a recognition by the CMA that the 45.52 was a market incentive price. We say it is a range, but what I'm submitting now, if one looks at 324, it is accepted on the evidence that the £6 or so CMA's cost plus is not a market incentivising price, it is a market foreclosing price.
Sorry, I've got the wrong.
I beg your pardon.
I've got the wrong paragraph or page.
324 of the judgment.
Page 302.
Page 302.
That's where I am. Sorry. Okay.
Paragraph
I've
324.
got the right one.
324. It's the second paragraph from the bottom. It says HG's argument.
Yes, that's what I've got. Okay.
Which is, it was our argument as well and Cinven's argument. It wasn't just HG's, but anyway. HG's argument, the CMA's case gave rise to an obligation on Advanz to set prices at a level which would deter entry mischaracterises the CMA's position. Charging prices based on cost plus would not necessarily have deterred other entrants from competing, even though, on the evidence before the tribunal, that would have been the outcome during the infringement period. Well, it is quite clear that Morningside and Teva would not have entered at the £6 cost plus, and it is quite clear that the £6 is a market foreclosing price, not a market incentivising price. And we do criticise the tribunal for rejecting the market incentivising price, possibly in favour of the cost plus, although with the caveat, and this is quite important when one is looking at all the factors as to what it makes a fair price, if one goes to page 286 of the judgment, and Mr. O'Donoghue is going to deal with post-entry pricing, but this is an important paragraph, paragraph 281, at the bottom, 281, page 286. As I say, Mr. O'Donoghue is going to do a post-entry prices. I'm only dealing with the market entry price. But the tribunal says, in reaching this conclusion, it's not necessary for the tribunal to accept Professor Valletti's evidence, that he was the expert for the CMA, that the price of liothyronine will only become workably competitive once the price has reached an equilibrium close to direct cost of production. We agree with the appellants that treating prices as workably competitive only once they fall to an equilibrium around direct costs would effectively equate workably competitive prices with perfectly competitive prices, a position which the CMA in its closing submission specifically disavowed. It is likewise not necessary for us to speculate as to what will happen to the price of Liothyronine tablets in the future or at what point they will become workably competitive. We have concluded that the February 2001 post-entry price is not a valid competitor because it's contaminated by the pre-entry abusive pricing, not because prices have yet converged from an equilibrium around direct costs. So Mr. O'Donoghue will pick this up, but it is important to note that the cost plus is A, a market foreclosing price, and B, is not one that seems to have been endorsed at paragraph 281, because it's getting close to a perfectly competitive price.
Can you explain to us almost in theoretical terms why entry is indicative of the rate at which entry will occur in a market such as this is indicative of fairness? Because at one level you say a company that's the incumbent monopolist sets prices at the level which keeps on pushing them up, pushing them up, pushing them up until entry is just inevitable, however high the barriers to entry, because there's still profit. And then the entrant doesn't want to drive prices down. They find a level which means there's a modicum of competition, but they're all making very high profit. Because nobody, if you're entering, you've got no incentive to drive the price down. You want to take X market share, 10, 15%, at a very high margin. So an irritant to the incumbent, but not a existential threat in which prices come tumbling down. Now, why is that relevant to fairness?
Well,
I mean, unless my thesis is completely...
I'll mark it. I'll mark it as a fail.
Isn't that what they mean by
what my Lord has said is relevant, clearly, and my Lord made that point in Finito in the Court of Appeal. We'll come on to that, paragraph 103. The point is it irrelevant? And my thesis is that you can't say that market entry pricing is irrelevant, which is what the tribunal said. Where we get to is one has to look at it as a balancing act.
Yeah.
And that is what the CMA and the tribunal did not do. The CMA didn't really do it because it said it was irrelevant. But clearly, you can have very high barriers to entry, and I'll come on to this. And you'll get to the stage where you will say, well, it's clearly not worth it. But equally, you can have a high barrier to entry. The price is high for a reasonable period of time. It spurs entry. New entrant brings in a fantastic product, and also the prices come down. But
not necessarily to a competitive level. I mean, I think this was explained to us in July, how the generic market, they find a different form of balance to that you'd have in a genuinely competitive market.
And so in answer to that, we say, and I just in our head, think about £60. So £60 was the market incentivizing price. We will come on to evidence in a moment where the price was £60. There was the price increase, and the Department of Health internally said, well, that is going to fund better distribution. But also, more importantly, we said that the post-entry price at £60 had a similarity with the market incentivizing price. And we said that the £60 post-entry was a workably competitive price. And that's why we wanted to put the two together. We wanted to put the £60 market incentivizing price. And in order to answer the very question that my Lord has just posed to me, is it too high? No, because several years later, with competition, it is around £60.
I think you're equating entry by a new company with a result which is workable competition.
Well, what I'm trying to do...
May not be the case.
Well, it may not be the case. We're saying, on the facts of this case, the CMA and the tribunal had all the evidence in front of it. And it's a very difficult question asking whether a market incentivizing price is a fair price. And one would then look at other factors. We say it is not irrelevant, as the tribunal basically said it was irrelevant. Because if you then look at how the price panned out after several years of competition, it is at that price. And is it still at that price? So,
I mean, I get you. If you say that they ignored it as a matter of principle, that's sort of what we were trying to avoid in Finito. And we're saying everything goes in. The relevance and the weight you attach to each piece of evidence is quite a different.
Correct, and that's why I put my counter-thesis to my Lord, which is that you can't say it's irrelevant. It could go. It could not work out, but you would look at the evidence and we say that the tribunal in particular had all the evidence and could have said £60 post-entry work could be competitive. Shows that the market incentivising price wasn't too high. And you end up with a situation where today the price, and we put this in our skeleton and the CMA object to it, that today, still today, it is around £60. And it has been £60 for the last 4 years, since October 2020, round about £60, the drug tariff price. And it is in a range which is closer to the market incentivising price than to the £6 cost plus. And you're in a situation, and I'm going to come on to it right now, you're in a situation where you've still got 3 players in the market, they are competing, you've got a secure supply line, and you've got much improved medicines to meet a clinical need, which we're going to come on to. And just so I flagged upon, we're going to see it. What happened was, with the encouragement of the MHRA, the regulator, Morningside, you see this from our skeleton, Morningside came up with smaller doses of 5 and 10 mg, not 20 mg. And before that time, and it's quite a toxic API, this liothyronine. It's quite difficult to put into a tablet. And what the patients were doing were crushing the tablet or cutting it in half with a knife in order to give them smaller doses. And the regulator encouraged Morningside to manufacture the smaller doses, which it did. And the evidence before the CMA, the evidence before the tribunal, was that smaller dose met a clear clinical need. So when one stands back at it all and looks at the evidence, the £40 to £60 range incentivised new entry. You had 2 new entrants which improved the security of supply, because when it was just Advanz, it was going out of stock, and we'll see the evidence of that right now. So it improved the security, it improved the medicine, the liothyronine. There was a lactose-free, there's a capsule, longer shelf life, and as I say, smaller doses, so patients didn't have to cut it with a knife or crush it into powder and try and divide it up. And the price today is the market incentivising price in 2012, 2013. And you compare that price with the CMA's cost plus, which is the market foreclosing price, and a price which is closer to a perfectly competitive model. And we say that is not what the Department of Health wants from its generic industry, as we saw in Scheme M. So if I could just go to the benefits of new entry in this case. We set them out at paragraph 32 of our skeleton. Which is at core bundle 80. So paragraph 30. And there we list them out. So there's the new 5 MCG, 10 MCG, and we see there the regulator expressly asked Morningside to manufacture the small to meet a clear clinical need. That was and we'll come up, for the more detail, we'll have a look at some of the annexes to our closing. A tablet with a longer shelf life of 24 months, a lactose-free Liothyronine tablet, capsule version, and we're going to come on to this first. The supply of Liothyronine itself was made more secure. And there was a lot of evidence on this from the experts at the trial, because we saw this in Scheme M. If you've just got one supplier, and that one supplier goes out of stock, then the patient suffers. If you've got more than one supplier, then the chances are you're not going to run out of stock, and you have a more reliable supply of medicines. And we'll have a quick look at some of the evidence. But before they introduced Scheme M, the government asked itself the question, well, should I have a tendering system, or should I have a scheme like Scheme M which promotes competition? So should I have a tendering, well, I only have one, so I pick one, or should I have a system where I promote competition and I've got more than one? And the reason they went down the promotion of competition route was to ensure that they were not stuck with just one supplier. And that was the expert evidence of Mr. Smith, Mr. Williams, along with other experts at the trial. But those are the patient benefits summarised. As I say, in our closing, and we put our closing in the second volume of the agreed supplemental bundle. And if I could just refer to that, please. So in our closing, so this is the agreed supplemental bundle, volume 2, at tab 13, page 543. And if you've got the hard copy there, what we did, tab 13 is the closing. If you go to tab 14, we put an annex. What we did, in annexes, we set out the evidence on various issues. So Annex 1, we'll come on to in a moment, which was the department's awareness of the price increases. Annex 2 sets out the regulatory context. This is at tab 15, at page 614. Annex 3, we set out the evidence on the effective powers to control prices at 627. Then at tab 17, the annex, the industry's portfolio approach. So that's Annex 4, set out all the evidence on the portfolio approach. And then Annex 5, which we'll come to also, at page 663, we set out the evidence on foreclosure and the non-price benefits. And it is Annex, so some of the detail on these patient benefits I want to just explore because they're in Annex 1 and Annex 5. So could I just pick this up with, there is a factual narrative which is not unimportant, and I'd like to pick this up at page 601, which is at tab 14. And if I could, it's indulgence, but if I could ask the court to have two bundles open, we'll need two bundles. We'll need this bundle that we've got, 601, but then the unagreed supplemental bundle. And where I'm going for the next few minutes is just to emphasise to my lords how important the Department of Health regards security of supply. So we've got two bundles, the unagreed supplemental bundle at tab 14, and I start with the narrative, the Department of Health evidence at the bottom of 601. And at paragraph 12, 13, 14 and 15, we have set out, I won't read it out, we set out the problem that Advanz had in 2009, 10, 11, 12 about underinvestment in security of supply. And if one goes, so, I mean, for example, at paragraph 15, Mr. Baton states, at paragraph 13 of his witness statement, the concerns department can be seen that from the correspondence in 2009-10, Advanz was ranked 82 out of 91, one being the best. And this led, as we say, to paragraph 16, 17, 18, to a meeting with the Department of Health on the 8th of May 2013. And there are two documents here in the unagreed bundle. There's the slide pack for this meeting, and then there is the notes of the meeting itself. And the slide pack, for example, we see at page 313 examples of stock report, inventory cover, watch list products. And we see many medicines there which are on a watch list. And if you're looking at the top of the page, you can see liothyronine, about 1, 2, 3, 4, 5, 6, 7, 8, about 9 down, is out of stock.
This may be, sorry,
I beg your pardon.
this is a slide pack.
Yes.
Starting at 303.
Yes, it is. For a meeting with the Department of Health
I see.
on the 8th of May 2013.
Yeah. Okay. There's no date on it, so.
No.
Okay. Right. Anyway.
And at page 313, we see quite a few medicines which are on a watch list because they, some of them are out of stock. And we see at 315, liothyronine is out of stock. And the tribunal refers to this, for example, at paragraph 8 of its judgment. But it's important to note that at this time, liothyronine was out of stock. And the meeting, the notes of the meeting are on the 8th of May. This is at page 322. And essentially, the department and the MHR, it's a meeting with AMCO, which is Advanz, at the department's house, at Skipton House. You've got Department of Health there and the MHRA. Because the department and the MHRA are concerned about shortages of the medicines. And here we have the notes of the meeting, and the evidence before the tribunal was that some of the price increases were to fund improved security and continuity of supply. But I just ask the court to note that there is a meeting which is concerned with shortages of medicines. The next point to note, if one goes to tab 17.
So it's the passage at 323 you want us to, under the heading D, is that right?
Yes, so we see there, that's the reason that there had been, that Advanz had gone out of stock, that the supplier had abruptly discontinued supply. Sorry?
Last line.
Last line of what?
Of D.
Okay. The API supplier had abruptly discontinued supply. Currently is the process of compiling data for the submission to register, which the company expects to send to the MHR on Friday. The MHR has agreed to expedite. So the MHR is agreeing to expedite because everybody is concerned that patients, and we'll come on to this in a minute, that patients are getting liothyronine. So the company is trying to get new stock. This issue, as well as the need to find a new also effective injectable presentation, company has 14, so this is the new company with the API, has 14 months stock to hand, so there shouldn't be an interruption to supply. But they are discussing.
So the new, sorry,
The new company has 14 months of stock to hand. They're trying to find a new company. The existing supplier.
what's this got to do with price?
I'm going to come on to that in a moment.
You don't get it from that.
No, we don't. But what I'm emphasising, there is contemporaneous evidence before the tribunal, 2013, about liothyronine being out of stock.
Right.
Then, to answer my lord's point, this is a factual narrative, which is important. At tab 17, at 325,
At the moment, I'm just sort of understanding that there's a problem with with Sandoz,
yes,
and there's an alternative source of supply of Peptido,
yes.
and Peptido's got lots of stock, so there won't be a problem. I don't understand at the moment what this is, other than obviously you don't want the NHS to run out of supplies of a drug. What's this got to do with price?
Two things. Can I go to page 325 at tab 17? Because at the time, so this meeting is on the 8th of May, and if one goes back over this, you'll see the same people on this email chain who met Advanz on the 8th of May. So on the 8th of May, they're talking about liothyronine, how we're going to, it is out of stock, but we're doing our best to get a new supplier. And the same people are given Advanz's price increase notification. And you see this from page 325, at the bottom of tab 17, 325. It says price increase notification. And what Advanz, every time it had an increase in price, it would notify the relevant people at the department of the price increase. And hundreds of other people. And at 326, we see, third one down, liothyronine is increased to 68.20. So as I said before, we've got a market incentivising price at around £60. And at this point, this is the same time, the price is 68, and the department has been notified of this. So this notification, and it says, please pass on to relevant individuals within your organisation. This comes to the person who was on the 8th of May, where they're talking about the stock problem. And the middle email, the CMA refers to at length in the decision. From a brief glance, these are mostly sole supplier. These are big increases without them having to provide any justification. They have us over a barrel. Is this the sort of thing in your investigation into phenytoin and others? Now, this email is trotted out quite often in the decision and in the CMA's arguments. One can understand why. But what one needs to look at to complete the jigsaw, my lord, is at 335 at tab 20, where, again, at the same time as Advanz is meeting the department about liothyronine being out of stock, having a price increase to £68, we have a query from an MP and a member of public about liothyronine being out of stock. And we'll see here at the bottom of 335, and there are two things I want to emphasise about this. First is that the difficulties with if you go out of stock, and secondly the price. So the government is saying that medicine supply problems, this is at the bottom, medicine supply can occur for a number of reasons such as manufacturing problems, difficulties in obtaining raw material or regulatory issues. In the case of liothyronine, the company responsible for the manufacture and distribution, Amdipharm, that's Advanz, experienced problems obtaining the active substance and as a consequence went out of stock. We fully appreciate the difficulties that this has caused for patients. The Department of Health and the MHRA worked very closely with the company, that's with Advanz, to help ensure that supply returned to normal as quickly as possible, and we understand that new stock is now available. The next point is important because if you go out of stock, then you fall back to unlicensed liothyronine. We understand that while the UK licensed product was in short supply, unlicensed alternatives were imported from abroad. And the MHRA wrote to healthcare professionals to explain the situation and to provide the clinical advice on the use of the imported alternative and a communication. So going out of stock is a real issue. And then we see on the top the initials SJ and II, with apologies for the delay in sending you to with thanks to that I there is the person who was at the 8th meeting who got the price increases. So your constituents are concerned that there is only one pharmaceutical company that is licensed to produce liothyronine. As you may be aware, before a medicine is marketed, it needs to have a license. Companies need to submit detailed information on the product's quality, safety, and efficacy to the licensing authority, and the license will only be granted if it's found to be satisfactory. And then it goes on. You can't force companies to get an MA. We fully appreciate the problems that can be caused by medicine shortages. I would like to reassure the department has well-established procedures for dealing with supply problems, and officials work closely with the pharmaceutical industry, the NHS and others operating the supply chain to help prevent shortages and to ensure the risks to patients. So again, and I can't emphasise it enough, that it is a key policy objective of the Department of Health that there is not a risk to patients because of a shortage of supply. And then, as to the cost, so by this time, the relevant person who was at the meeting with Advanz about improving security has been notified of the price increase. Your constituent also refers to the cost of liothyronine and the influence this might have on prescribing. We cannot comment on the cost of liothyronine from outside. However, it is important to note there are a range of costs involved in research, development, production, and distribution of medicines. And all I'm getting there is that the department knows that the price is £68. Has discussed with the company Advanz about improving supply of many medicines and is not pushing back on the cost. It is not saying the cost is outrageous. It is not saying what it should be £6 and we'll look into it. It is aware of
which of the costs which are said to vary widely in fact explain the difference between the price of liothyronine in the UK and elsewhere. It's not research and development, is it? Because it's an old medicine. Well, what? I mean, that's an entirely generic answer. It's an entirely generalised comment at the end.
It is,
It's
but
got no relevance to this case.
well, it does in the sense I'm trying to draw factors together which show that the market incentivising price of a range of 40 to 60 is fair. We do that by looking at the post-entry workable competitive prices. And in my submission, my lord says it's irrelevant, but it is relevant to this extent that there was a shortage of liothyronine, to such an extent that there was discussion at the Department of Health. The department knows that the price has gone to £68 and is still saying that the cost of liothyronine goes towards the distribution of medicines, research and development of medicines. It is not saying to the Member of Parliament or to the member of the public, this is a very high cost. There is a certain, that the department appears to be relaxed about paying £68 reimbursement price for liothyronine, in the knowledge that there is
So
a...
are you making these submissions on the basis to go to the acquiescence argument, or what's the... What's,
Okay, well,
at the moment I'm struggling to understand why the comments by somebody from the Department of Health to somebody who's been approached by a constituent of an MP, which are entirely generalised, I think, have anything to do with the argument that I thought you were dealing with, which is entry prices, incentivising entry.
I'm trying to draw some strands together about the level of the price. So my market incentivising price is a range of 40 to 60. It's put to me, well, that could well be unfair. I say, well, actually compare it to the post-entry workably competitive price. The price now shows it's not unfair. Also, I say, at that relevant time, in 2012-2013, there was an issue about liothyronine and other products being out of stock. And when someone queried about the cost of liothyronine, there was no pushback. And so the bright line point could go to the acquiescence point, and we say it does, but it goes to who is the customer here? The customer is the Department of Health.
But fairness is an objective test, is it?
It is, yes, but one, and is whether it is an objective test, but whether you are looking at what the customer is reasonably willing to pay for. So ultimately, one is, you're not being forced to pay it. What is the customer reasonably willing to pay for liothyronine? And in my submission, we haven't had any evidence from the Department of Health in any of this. And we have to try and draw some strands together from very limited disclosure that we get. And in my submission, it gives you gives one an indication that the department was reasonably willing to pay £68 for liothyronine at this time, knowing that there were problems with liothyronine going out of stock and the cost of liothyronine being used to subsidise other...
You're entitled to say the customer was, at least for a number of years, sanguine.
Yes.
Did just remind us how the complaint came about. Who lodged the complaint with the CMA? That was a government agency.
I think it might have been, I think it came from, when the price went very high, the Times got hold of it. And Mr. Hunt, the then Secretary of Health, I think then contacted
It was a complaint from government to the CMA, I think, wasn't there?
Yeah. So
2017.
But that was not at this time, this was in 2017. And so Mr. Hunt, the Secretary of State, as a result of the Times and the newspapers getting hold of it, then contacted the CMA. But all I'm trying to do is, there are two things. I don't want this to. There are other things to look at, but there is undoubtedly a concern about shortages of supply of medicines. And can I just go to Annex 5 and then just finish this?
Just before you do,
Yes, I'm sorry.
one point you just made,
Yes.
I think, was that one of the things this shows is that the price is justified by the fact that the cost of research and development of a range of medicines.
Yes.
Do you get that from this email or anything
Well,
else?
I get that from this email. It's only a one-liner. As I say, we haven't been able to... We put forward in our annexes evidence where we say the Department of Health looks at generic pricing on a portfolio basis. And we put forward evidence on this. The Department of Health doesn't come forward, so we can't cross-examine the department. And we get very little disclosure from the Department of Health, this being one such email. Now, one can say, well, it's not worth a row of beans, it's irrelevant. We say, with the limited information that we get from disclosure, it at least, as my Lord says, they seem to be sanguine about the cost of liothyronine being used generally to improve the research and development distribution of medicines.
But it doesn't say that, does it? Apart from the plural medicines.
Well, there we go.
That's it, is it?
Yeah, if it had said medicine, one would have said, right, we're now talking about liothyronine. And if it is liothyronine...
So I made the point to you that we know that to the extent it refers to research and development, it can't be talking about liothyronine.
Well, with great respect, that's not right, because this is what we're going to come on to look now. Because Morningside did spend considerable amounts of money in research and development trying to work out how to get smaller dosages to meet a clear clinical need. Generics do invest in research and development.
Okay, so you say it's wrong to regard this as a sort of long out of pattern medicine that couldn't be improved.
Yeah, I mean, generic companies invest a considerable amount of money in improving existing medicines and in new pipelines. That's the whole purpose of Scheme M. I mean, that's part of what Advanz's case was on acquiescence, which is a lot of this money gets reinvested. Can I go to Annex 5, which is at tab 18? Which is at page 663. This is where we dealt with, so at tab 18 of agreed supplemental bundle to, this is Annex 5, foreclosure and non-price benefits. Can I pick it up at page 668? And I'll take this more quickly until we get to the end. So at paragraph 21, at page 668, we set out all the evidence that came out at the trial about how the Department of Health does not want shortages in the supply of medicines. And at paragraph 22 and 23, we refer to the email of the 3rd of July, which we've been through. Then at paragraph 24, we set out the policy documents that the department have for ensuring there is no shortage in medicines. At paragraph 28 and 29, we referred to the evidence of Mr. Baton. 29, he explained on oath that the price increases and the revenue funded the remedial action. At paragraph 31, we referred to the authoritative auxiliary report, and that we needn't go to it, but that's at tab 23 of this bundle. Value to patients, the overall value delivered to patients, while price is an important indicator, a key aspect of this sector is access to medicines. So this is an auxiliary report into the supply of generic medicines. It's a very, very important report. This is particularly the case for medicines with complexities, small market. It is important to consider the risk of excessively low prices, which is discussed, could increase the chance of there being unserved markets. So this was an independent auxiliary report emphasising security of supply. Then we set out the economic expert evidence, and in particular the evidence of Dr. Chowdhury, who was the expert who was called by Cinven and was essentially the author or a big contributor to the auxiliary report. And I asked the court to note paragraph 33, where she criticised the CMA's economist, Professor Valetti. She says, by focusing on low prices as the sole measure of consumer welfare, he misses a critical aspect of the market context of the supply of generic medicines, which is security and continuity of supply. This was also the evidence of Mr. Smith. And then we get scheme M. So we had a lot of evidence on the Department of Health being concerned by shortages. Can I then just go to paragraph 41 onwards? Which is, to a certain extent, deals with the research and development in generics. So we set out the evidence before the tribunal and also before the CMA, I might add, on the 5 mcg and the 10 mcg tablet. So paragraph 42 and 43, we see that Advanz tried to do it, but it could not progress the development because of its marketing authorization. At paragraph 44, we referred to the documents which referred to the patient having to crush or cut the 20 mcg. And in a report at 45, in a report, it says interviews with endocrinologists and commentary on patient discussion forums indicate that patients are often prescribed lower dosages for which they have to cut the mcg tablets for lack of availability of low-strength options. The launch of low-strength options would address this unmet need. One said, most patients are on doses that are higher than the optimum. Given that too high a dose could be clinically damaging, I would prescribe the 10 mg as a premium. So there was a clear clinical need here. And then we see what Morningside, this is at 47, 48, 49, what Morningside told the CMA. The likelihood of clinical damage is confirmed by Morningside in a response to a Section 26 notice. The dosage of the API is only a few millionths of a gram, and the drug has a very high level of biological activity, meaning the tolerance for any errors is extremely low. The dosage of liothyronine incorporated into each tablet was so low that variability of a few thousandth of a milligram would lead to dosage that would be considered severely out of specification. This is, one has to remember, we're in the pharmaceutical sector here. And someone is saying that this is an important improvement. And Morningside told the CMA that there was a clear clinical need for certain patients to be treated with a lower dose. And we see there the reference to clear clinical need. And in addition, Morningside told the CMA it had given tremendous support to develop its product during the assessment period, and conference, face-to-face calls. And we say that there was a real, genuine attempt to bring to the market a much improved version of liothyronine.
So I'm, again, sorry to try to get my bearings, but I'm just struggling to sort of connect what you're submitting to us to your grounds of appeal.
Yes.
I mean, are you now saying that the CAT erred as a matter of fact in its evaluation of the evidence and gave wrong weight to certain evidence that was put before him and put before it, and it should have done one thing rather than the other? Or are you making or dealing with your ground one, which is said to be an error of law? I mean, I'm just struggling to understand why we're hopping around this evidence.
Well,
And sort of picking little snippets of evidence here and there and looking at a schedule here and this. I'm trying to connect it to what your actual intended ground of appeal is.
ground of appeal is you are incorrect. So the ground of appeal is you are incorrectly interpreting the test for an unfair price. Why? Because you are ignoring, as a matter of law, entry incentivizing prices. Why is that relevant? Because that entry incentivizing price brought this clinical benefit. We'll come on to how the CMA deal with it and the tribunal deal with it. Two things, or three things actually. The first is that the tribunal was wrong as a matter of law to say that market entry incentive pricing was irrelevant. Secondly, it was wrong to go on and say, if it is relevant, I don't have to balance the price with the benefit. It's clear law that it's actually embedded in the whole notion of an unfair price,
Yep.
that you balance price and benefit. So they were wrong on that. That's two errors of law.
Yep.
And the third error of law is they didn't really consider, I think it's at paragraph 321, and we'll see it in a moment, but to say that the tribunal had any meaningful balance of price, market incentivizing price, and the benefits that we've seen is nonsensical. It just did not carry out any...
Where's that in your notice of appeal? Grounds of appeal?
It's in our skeleton.
Well, no, that's not what I asked. Because that's a challenge, or that's a challenge to fact finding.
Well,
it's just not in your grounds of appeal.
Well, I'll have to check this in the grounds of, but it might
If you go to page 19. First two points were points that you do have in ground one. But the third point, which is what I understood you to be asking us to look at these various bits of evidence, just isn't there.
Well, it is an error of law, because if one doesn't make the assessment, one doesn't do a balancing exercise, then that is an error of law.
At some stage, can you take us to the CAT tribunal on this point? I mean, I remember that the CAT did say, as a question of principle, they rejected market entry and some incentivising prices. But then when I read the paragraphs, I wondered whether it was a question of law or a question of fact. They were talking about high entry barriers on the facts of the case.
Shall I do that now?
I think it would be helpful just so we can really drill down. I mean, it's...
So let me try and do that now. So in our I'll go to the decision and then I'll go to the tribunal. But if I just pick it up at our skeleton.
Am I right in thinking that there was common ground between the experts that entry incentivising prices didn't reflect necessarily the outcome of effective competition.
Well, it's true. I mean, it doesn't necessarily. But, and that's the first point the tribunal makes, that an entry incentivising price is not the product of workability. But that's because it's an entry incentivising price.
Yeah.
What you can do is say, you can, if you've got the evidence, you can then look post entry and say, actually, the two are not dissimilar.
But it may come down to whether, I mean, there is a slight oddity in the tribunal says that this is a question of principle. It then goes on to refer to factual reasons why they don't think it was relevant, including high entry barriers and the fact that a very high entry barrier with a very high profit might mean that you enter and you still make a stonking great big profit, even though you don't reduce the price. So that's sort of a factual issue as opposed to a legal issue.
Okay, well, and I'll go to that.
Anyway, you take. I think it would help us to see the decision and the judgment, so
Yes.
we can understand its structure in a bit more detail.
And as a matter of law, we say that it was the tribunal made an unreasoned
Yes.
dismissal of the patient benefits, that it just was not in law a reasoned decision. And so if I go to the decision first then, and then we'll go to the judgment. The decision is Core Bundle 2, page 635.
Sorry, page 65.
Page 635 is at paragraph 5353. Now, I apologise to a certain extent that I have tried to labour that shortages of medicines are an important policy objective of the Department of Health, and I've tried to show that new entry stimulated a new product, a new medicine, smaller doses, which met a real clinical need. That's the 5 and the 10. And at 5353, this is the sum total of the reasoning in dismissing the patient benefits. In this 1,000 plus decision, this is all we get.
Sorry, I've got myself into the wrong bundle.
I'm sorry, so it's Core Bundle 2, the decision.
Sorry.
Yep. So Core Bundle 2 at page 635 of the bundle, and it's paragraph 353. So this is all we get about the patient benefits. We're in the pharmaceutical industry, benefits, clinical needs are highly important. Does not consider that in the case of Liothyronine Tablets, entry is likely to generate the non-price benefits, increased output, qualify improvements, efficiency and introduction of new and better products that competition can bring to in other markets. A just talks about what it doesn't increase the volume. And then B, these 4 lines and footnote 1061 is the sum total of the reasoning. As Liothyronine tablets are an old and established drug with limited scope for improvement, statement of fact, entry has not resulted in substantially increased quality or better products. So that is a statement that entry has not resulted in substantially increased quality or better products. And then one is referred to footnote 1061. In the CMA's view, the benefit of any incremental improvement in security of supply and shelf life that has arisen as a result of new entry is disproportionately small compared to the cost to consumers, that's the department, of stimulating that entry via increased prices. So there are two statements here. The first statement is in B, that entry has not resulted in substantially increased quality or better products. We say that is just plain wrong. You can't make that statement without referring to the smaller dosages. The MHRA has said that that product met a clear clinical need, because patients were having to cut it, crush it, taking too high a dosage. And one cannot just dismiss that in a line like that. And when you get to the second statement, is in footnote 1081, it acknowledges security of supply and increased shelf life, but doesn't mention the smaller dosages, doesn't mention the lactose, doesn't mention the capsule. And there is no Department of Health evidence or medical evidence to back it up. There's no reference to the fact that there were shortages in 2013. And there is no analysis whatsoever why the £45, £60 odd pound range, market incentivising price, is not worth these benefits. So we complained about that, and that's why we really tried to articulate to the tribunal the research and the development that Morningside and Teva went into improving the products and the security of supply. We'll come on to the other reasons in a moment, but my lord asked me where it is in the judgment, and we refer to this in our skeleton at paragraph 52, which is the tribunal's unreasoned dismissal of patient benefits.
Did you say 52?
It's in our skeleton at 52,
yeah.
But the relevant bit is at paragraph 321 of the judgment, which is at core bundle 301. So I'll come on to the errors of law that it made in its interpretation, but we get. So let's have a look at 321. So as to the appellant's contention that applying a benchmark below the entry incentivising price will deprive consumers of the potential benefits of competition, we agree with the CMA's position that it is not part of the United Brands test that the price benchmark must be set at a level to facilitate competition. The test does not presuppose the potential benefits of competition are such as to justify and render non-abusive whatever price is needed to incentivise other new entrants, nor does the test require a comparison to be made between, on the one hand, the benefits of competition with, on the other hand, the harm resulting from excessive prices. If I just pause there, we say that there are at least two material errors of law in that paragraph. First, it is embedded in the test of unfairness that you have to balance benefits with the price. And secondly, it is nonsensical to say that competition law is not about promotion of competition. And we'll come on to the authority for that. And then this is where the tribunal simply brushes aside the patient benefits. If such a comparison were to be made, the CMA concluded in the decision that the incremental improvements would have been made in the provision of Liothyronine Tablets since Teva and Morningside began to compete, that is to say, the availability of different dosages, a longer shelf life, lactose-free option, security were disproportionately small to justify the increase in prices needed to stimulate entry. We agree with that assessment. It's an old and established drug with limited scope for improvement. And we say, we make two criticisms about that. We say it's plainly wrong, and we make two criticisms. First, the CMA did not make the assessment the tribunal says it did. Just simply didn't. we've just seen that the CMA did not even consider the benefits of the different dosages. So the tribunal cannot say that the CMA concluded that that these dosages the price were disproportionately small. It just didn't consider it. So the CMA did not, that's the first criticism, it just did not make the assessment the tribunal says it did. And second, to the extent that the tribunal picks up footnote 1061 of the decision and the reference to disproportionately small, we say it suffers from the same lack of any analysis. There has to be a fair evaluation of the patient benefit evidence. And simply agreeing with a throwaway line in a footnote of a 1,000-page decision imposing quasi-criminal penalties is simply not good enough. And we're talking about regulating the price of pharmaceutical products here. And these 5 or 6 lines dismissing the patient benefits, we say is in law, inadequate, and is an error of law. But it all stems from the errors of law that the tribunal makes. And maybe with the time left, I can just explain why the tribunal made the errors of law it did. But the tribunal makes no assessment of its own here. It simply agrees with the CMA's alleged assessment, but even the CMA didn't assess that the new dosages were disproportionately small. The tribunal just cannot say that. Can I then go back to, in this judgment, actually, to the tribunal's conclusions? So the tribunal's conclusions on market incentivizing prices starts at 317. Mr. O'Donoghue, we need to cover it up, but when one goes at 317, one can cross-refer to 317 as well. 137, Mr. O'Donoghue says is relevant, 137, and it is. That sets out the scene for what it's going to say at 317. So at 317, in our respectful submission, the tribunal has made some fundamental errors of competition law. At 317, it says it's common ground between the experts that entry incentivising prices do not reflect the outcome of an effectively competitive.
Sorry, just before you...
Yes.
Sorry, do you say there's something wrong with 137?
No, it was just Mr. O'Donoghue taking me out of my stride. But no, it is wrong because...
Do you make a criticism of what's said at 137, or do you think that's okay?
Well, for the reason I'm going to, when I get to 318, it is a fundamental error of competition law at 317, at page 234.
Yeah, so I'm just trying to...
No.
I've got 137 open since I'm told that that's relevant, and it does indeed appear to be relevant. But in 137, the CAT is expressing, as I read it, its view of the legal test. And what I'm asking is whether you disagree with anything that is said by the CAT in paragraph 137. If so, what do you disagree with?
Well, it's the first sentence, and it's the first sentence of 318. the tribunal, in short, we agree with the CMA that there is no legal principle that its cost plus benchmark must be no lower than the price needed to incentivise entry by other competitors. Under the United Brands test, as clarified in Fenitone, there is no absolute requirement that a fair price must be no lower than an entry incentive.
So you say that is legally wrong?
Yes.
Okay.
And if I go back then to page 300,
And just when you say it's wrong, is it wrong in an absolute sense, or is it wrong in this relative sense?
sense, yes. Because what happens is they firm it up at 317 and 318. And what we really take issue with...
Just to begin, 137 says must be no lower.
Yeah.
It may or may not be on the facts of the case.
Yes. But...
Anyway, your main focus is on... Okay, we've read 137. We will... Yeah. So you should have just told Mr. O'Donoghue to shut up. It would be much easier.
317, page 300. The first point that the CMA, the tribunal makes, is that a price incentivizing, an entry incentivizing price, does not reflect the outcome of an effectively competitive process. And we say, well, it may or may not. It's certainly the start, because it's an entry incentivizing. But as we see on the facts of this case, the market incentivizing price does actually reflect the outcome of an effectively competitive process, because the prices today are, drug tariff is at £60, and it was that in 2012, 2013.
Well, that's only right if your argument on post-entry prices is right.
Yes.
So
Well,
why do you need the entry incentivizing price if you can rely on the post-entry price?
well, because it gives you the benefits. And I also rely on, and we'll come on to this also, I rely on not just, there's two issues on the post-entry. The first is Mr. O'Donoghue is going to refer to, which is whether the prices at 60 odd were the product of workably competitive prices. But also we've got this application to adduce the evidence today of the drug tariff prices, which is in our skeleton. And I'll come on to this. So if one looks at our skeleton at paragraph 14, and I do need to deal with this. Paragraph 14, we have a graph which continues the drug tariff price beyond the judgment. And I will take my lords through this. But paragraph 14 of our skeleton continues the drug tariff price today.
So sorry, no, it's nothing to do with the microphone. I don't have the benefit of amplification. Sorry, there was a helicopter went past.
Oh, sorry. I can't.
And you were speaking quite softly. I just
sorry, I
couldn't hear it.
So there are 2 points on post-entry.
Yeah, you need to be on my non-deaf side.
2 points on. First, Mr. O'Donoghue is going to deal with whether the prices post-entry were the product of workable competition, which would justify the level of the entry incentivizing price, which we say is relevant. It's relevant because it introduced these benefits. But secondly, if one looks at paragraph 14 of our skeleton, at core bundle 75, we are asking my lords to consider the current drug tariff price today, and I will come on to this, but in a nutshell, at the trial, the CMA applied to rely on the drug tariff price post-decision and post our pleadings to show that the prices were falling. And the tribunal relied on the new drug tariff prices that the CMA relied on. And what we're doing is we're just continuing that process. And we're saying, actually, they weren't falling. Look at them. They are fairly stable, and that's of relevance.
I should, on lad and martial grounds, we'll hear all this de bene esse, but to prevent Mr. Holmes jumping up and down, we'll just get on with it and then we'll decide later.
Yes, okay, thank you. So, can I go back to 317 of the judgment at page 300? I'm not sure that the tribunal makes a reason here, it just makes a statement. But it says that entry incentive prices do not reflect the outcome of an effectively competitive process. Well, it may or may not. But clearly, at the beginning, it is incentivising entry. And
would it be better to put after do not reflect or do not necessarily reflect?
Correct, yes. And I would take an objection.
At some point, I mean,
at some point, yes.
Just tell us whether, just give us a reference to what the experts actually agreed, whether that's an absolute statement or a qualified statement.
I will do. Then, paragraph 318. The tribunal says, we consider that treating entry incentive prices as a valid benchmark would be incorrect as a matter of legal principle.
Yeah.
So that is quite a stark statement made. It refers to my Honourable Justice Green's judgment in Gutman that is concerned with the protection of consumers from unfairness. But I just want to respond to the first sentence of 318, and it is necessary to go to the Court of Appeal's judgment in Fenetoi, and that's at Authorities Bundle 3. That's at tab 37. So all I'm dealing with here is whether market incentivising prices are relevant as a matter of principle. And it's at Authorities Bundle 3, tab 37, page 1297. That's where it starts. My volume 3. It's tab 37. Is
Yes.
that the finish?
Yeah.
And it's the paragraph 90 at 1323. 1323. Paragraph 90. All I'm doing here is responding to the tribunal's fairly stark statement that entry incentive pricing as a valid benchmark would be incorrect as a matter of legal principle. And it's paragraph 90 and 91. And 91 is the key. In the decision, the director stated that in principle, a price was excessive if it is above that which would exist in a competitive market and where it is clear that high profits will not stimulate successful new entry within a reasonable period. Therefore, to show that prices are excessive, it must be demonstrated that, one, prices are higher than will be expected in a competitive market, and there is no effective competitive pressure to bring them down to competitive levels, nor is there likely to be. The tribunal commented, while there may be other ways of approaching the issue of unfair prices, the director's starting point, as stated in 203 of the decision, seems to be soundly based in the circumstances of the present case. So, in NAP, which was the very first judgment ever to reach the CAT, as my Lord knows, there is a recognition that you can, when you are looking at the combinatorial approach to unfairness, so unfairness, you're looking at lots of factors, you can look at market incentivizing prices, because it would be a signal to market entrants, and those market entrants may bring much better products, and they, when competition comes in, it will bring prices down to a competitive level. So to say that as a matter of principle it is irrelevant, or it is, in my respectful submission, plainly wrong.
This is just a narrative of NAP.
Yeah.
It's not part of the reasoning or the decision in the Court of Appeal.
That is correct, but my Lord Justice Green summarised the cases in order to essentially the Court of Appeal and my Lord Justice Green said that there is no one single test. One should look at a variety of factors, and in my submission, a market incentivising price is one such factor.
The basic intuition was that we were concerned, I remember very clearly, that there were artificial limits determining what might be had to be theoretically admissible.
Yes.
And we thought that on both sides, both the CMA side and the defendant undertaking side, they were entitled to put forward whatever evidence they thought was appropriate, but the CAT then had to weigh it.
Yes.
And then the CMA had to weigh it and the CAT had to supervise it and do the same.
Yes.
So there's nothing ruled out and nothing ruled in. But
correct.
It doesn't mean to say that on the facts of the case some things may be remote and largely irrelevant factually.
100%, yes.
I'm reading this 318. It is, if it said as the valid benchmark, would be inconsistent as a matter of legal principle.
And
What are they really getting at when they go on to then qualify by reference to a series of essentially factual matters which track the case? I get the point, that is probably putting it too bluntly as they do in sentence 1.
Can I address that point? Because maybe to be fair to the tribunal, it then goes on at 318 to refer to higher entry barriers.
Yeah.
And again, to be fair,
They say in a market such as this.
And I would need to go to my Lord's judgment in Fenitorin at paragraph 104, which is at 1327. So in 103, my Lord is referring to niche markets, etc. And 104, my Lord says these features serve to distinguish the present case from other markets where patent expiry remove the principal obstacle to market entry. Where there are no material barriers to entry, high prices can act as a magnet to entry, which in due course drives prices down. Many markets are thus self-correcting. And you can't block an efficient signal which would otherwise promote market entry. Now, we agree with that, but so we disagree that market incentivizing prices are just wrong as a matter of principle. And yes, if there are material barriers to entry, they will be considered in what we say should be a balancing exercise. Mm-hmm. And just on this, we can go to the decision at, if you've got it, Core Bundle 2, page 507. Because one has to be very, very careful about just saying well, if there are material barriers to entry, I'm going to exclude it. I'm not doing the balancing exercise. So page 507, in the decision, we see that where the CMA, and this is, so core bundle 2, page 507, this is where the CMA sets out the technical and regulatory obstacles amounting to the barriers to entry to new entrants. And essentially it refers to two. So at 134 it says, in order to enter the market, potential entrants need to develop and manufacture Liothyronine tablets, obtain regulatory approval. The evidence demonstrates that doing so is difficult and typically takes several years. It sets out first, while it appears that the API is readily available, it's difficult to manufacture, in particular due to the very small quantity of API used in each tablet. In fact, Advanz itself had difficulty producing a consistently stable product, resulting in MHRA requiring Advanz to apply for a batch-specific variation. So it is difficult to manufacture. That's the first point. That's the first barrier. And the second barrier you see at 137, which is not only difficult to manufacture, but, so the CMA says, and this is correct, having developed a product which a company believes to be stable, there are strict regulatory standards to meet. The MHRA has confirmed that it has implemented rigorous pharmaceutical and clinical testing requirements for thyroid hormone products, liothyronine. Consistent with this, views from companies seeking to enter the market suggest it may be difficult to meet the requirements for obtaining an MA in the UK. And then you get the evidence relating to Morningside, which did. And my simple point on this is that the material barriers to entry, if they exist, and we're talking about the pharmaceutical sector here, and it's probably one of the most regulated sectors in the UK. The pharma, because one is dealing with patient safety. So it's not a commodity grain of sugar. The pharmaceutical drugs are in a sector where there are rigorous safety requirements and regulatory requirements. And to say, well, that is a material barrier to entry and therefore we don't even look at a market incentivizing price per NAP, in my submission is wrong. One has to then go on and do the assessment. And that's where we say that the tribunal made its second error. Its first error is it says that a market incentivizing price is not relevant as a matter of principle. Its second error is at 319, but at the beginning of 321, the 301 of the judgment, where the tribunal, before it summarily dismisses the benefits, says, first of all, that the United...
Just jump, sorry, I'm a few steps behind. If one assumes, for the sake of argument, that the CMA and the CAT are correct and there are high barriers to entry, do you accept that that naturally cushions the incumbents so that they can push prices up and up and up until the point that a high price does begin to incentivize entry?
It could well do. I mean, that's a plain fact. But also, it may you may not get to the stage where it pushes up and up and up and up.
But it may stay below the level to keep entry out.
And NAP says that you have prices above a competitive level. That's implicit in NAP. What the tribunal said. You have prices above a competitive level. You couple that with the Court of Appeal in the races saying that excessive pricing is not per se not permitted, and that's what the Court of Appeal said in Out the Races that it is not a regulation about prohibiting excessive prices, it's about unfair pricing. And then you look at NAP and you ask yourself the question, will their prices come down to a competitive level? And they may even fall below the market incentivizing price. And if they do fall, or at that level, you then have the benefits of competition. And this is our.
But assume everything you've just said is absolutely correct. That might happen. You're still equating the end result with workable competition. And it doesn't necessarily follow. You may get competition, may just be at a very high level, enabling all the participants who have entered to earn very high profits. Why do you then say that necessarily means workable competition in the competition law sense?
Well, it's not just workable competition. Again, a factor would be, is there symmetry between the market incentivizing and the workable competitive price? So, but it's not just that. Let's assume that, and take At the Races, because fairness, embedded in fairness, is the value to the customer. You just don't look at price, you look at the value to the customer. And let's assume that my lord is right, that the price is going up and up and up, but it incentivizes one new entrant who brings a fantastic product, a life-changing drug, much better than the existing incumbent. And you would get evidence from the Department of Health saying, actually, I would be prepared to pay that much higher price. So the incumbent, yes, has earned a very large margin, but it has been a price signal to an entrant who's brought in a much, much improved drug. And all I'm making a very simple submission, really, is that if you've got the evidence, then you assess it. And no one ever assessed whether 40 to 60 pounds was worth the benefits that I've tried to show this morning. We know that the £6 cost plus would have foreclosed market entry, and you would never have got those new, smaller dosages, which is the assumption that the tribunal makes. It would have foreclosed entry. And in my submission, if one is attempting to regulate the pharmaceutical industry, one should ask the question, is that 40 to 60 pounds worth the improvements in liothyronine? And that is a balancing exercise. And that balancing exercise is embedded in the notion of fairness. And just two authorities, just to so that we're under no misapprehension on this. The first is my Lord's judgment in phenytoin.
There was something, I remember we argued about something called value in phenytoin. What was meant by value in a pharma case? Yes,
we did, but that's not the bit that I want to go to.
So just before you go there, you finished with 318? Paragraph 318?
Yes.
So can you just run through that briefly? I mean, do you accept any part of it? Do you accept all of it or none of it? Or, I know you say you don't agree with the first sentence.
Okay. Shall I? Okay, so I don't agree with the first sentence. As noted in London South Gutman, the law relating to abuse is concerned with the protection of consumers from unfairness. Well, I don't disagree with that, but I disagree with the implicit or the subsequent statement that the tribunal makes, which says that protection of the consumer directly is essentially the end result. Chapter 2 is concerned with promotion of competition. So I don't disagree with the second sentence, but it is not the end of the matter, as we'll see in a moment. The level of entry, the next sentence, the level of entry is a market with high barriers to entry, whether in terms of entry costs must be high enough. Well, that is a statement. The higher the barriers to entry, the higher in a market such as this, with barriers to entry, though not insurmountable or exceptionally high. Not sure we did recognise that, but the price charged by an incumbent could.
I think that's a reference to your Mr. Clayton's speaking notes at 48 and 49, which do seem to at least recognise that there are high barriers to entry.
That is absolutely true. I mean, it's just exceptionally high. They were we've just seen them in the decision.
You take issue with the word exception.
Yeah, I mean, we've just seen them in the decision. That's why I went back to the decision. The product is very difficult to make, and you have strict MHRA requirements to satisfy.
Okay, but are you saying that's a view that the tribunal could not reach on the evidence?
Well, even if they are exceptionally high, I would, in my submission, as a matter of principle, you still have to carry out the balancing exercise.
Yeah. Okay.
And so when you get the price charged by an incumbent could be excessive, well, it could, but it could not be.
Right. So you don't disagree as a matter of principle with the proposition that there could be excessive and unfair pricing below the level required to incentivise other entrants to join the market?
Absolutely, yeah, that's plain. But what I'm trying to do is to really the CMA did not do a proper assessment because it said that market entry incentivising prices was essentially irrelevant as a matter of principle. We don't need to worry about them. And we say that in the pharmaceutical industry, that is not sound as a matter of policy, let alone price regulation. Because the whole generics industry is about promoting competition and bringing better medicines into the market. And if you've got more than one supplier, you're at less risk of shortages of supply. So of course, if you've got material barriers to entry, it could be that it goes to such a high level that it's excessive. But as I come back to my basic point, which is, at the end of the day, we're talking about whether the price is unfair, and embedded in the test of unfairness is this balancing exercise. And we see that in the passage in Phenytoin, in the Court of Appeal, which is the Intel case. It starts at page 1321. So this is Authorities Bundle 3. So 1321 at the bottom, my Lord Justice Green summarises the Court of Justice in Intel, and we go over the page, and at paragraph 88 at 1322, my Lord again cites what happened on appeal, and I would ask the court to note just below the letter F, letter F, the analysis of the capacity to foreclose is also relevant in assessing whether a system of rebates, which in principle falls within the scope of the prohibition, must be objectively justified. In addition, the exclusionary effects arising from such a system, which is disadvantageous for competition, now these are the words I emphasise, must be counterbalanced or outweighed by advantages in terms of efficiency, which also benefit the consumer. Now, when one looks at those words, must be counterbalanced or outweighed by advantages in terms of efficiency.
May. Sorry, am I reading the wrong place?
No, G, maybe. So what the European Court is saying here is you can have a conduct which forecloses the market, but which may be objectively justified, because the the benefits to the consumer need to be counterbalanced and weighed against the foreclosing effects.
Is it relevant in that case that we were dealing with preclusionary discounts, which the test was an AEC, and as a fishing competitor test, so it's effectively a predatory pricing test, where you were balancing the fact that it was a very, very low price given to, for example, Dell, who was one of the big customers in that case, against benefits to competition or the exclusionary effect against AMD. So this wasn't a high price case. I mean, I get the point. I mean, in principle, there's a balance. Get that. British Airways was also a discount case where you were balancing low prices against benefits. I see the broader point, balance.
Well, okay.
Is this a distinguishing feature?
No, because of the Court of Appeal's judgment in At the Races. And At the Races, as my Lord knows, Lord Justice Mummery was very keen to point out, and that was an unfair pricing case. In the relevant paragraphs, we can have a look at them. The Court of Appeal, Lord Justice Mummery said, this is not just about cost plus. I've got to look at the value to the purchaser. So if we can quickly, before lunch, look at that, because it is important. I'm sorry about it. It's at volume 2, tab 23. And At the Races is the answer to the question that my Lord just put to me. I'm trying at 321 to say that when the tribunal says you don't balance anything, that's not in the test of unfairness. That is just plain wrong.
Well, I mean, you're right. If the test, as we were trying to establish in Finito, is that nothing's ruled out and nothing's ruled in, necessarily, inevitably, automatically, then there's nothing which precludes it from being analysed as a matter of principle. It all turns on the facts.
Well, it does. And that's what my Lord said in Finito. But nor does the test require a comparison to be made between the benefits of competition with the harm resulting from excessive prices. That's what the tribunal said in 321. Nor does the United Brands test require a comparison to be made between the benefits of competition and the harm resulting from excessive prices. And in my submission, it plainly does. And Intel said, look at objective justification. You do have to counterbalance the benefits. And At the Races makes it absolutely crystal clear in the context of unfair pricing case. And that's at paragraph 218, at 702. And the very last paragraph, 281, at 717. So at 218, as my Lord knows, Lord Justice Mummery was saying that the issue there was whether cost plus was the end of the matter. And at 218, for all the above reasons, we conclude in holding that the economic value of the pre-race data was the cost of compilation plus a reasonable return, the judge took too narrow a view of economic value. He was wrong to reject the contention on the relevance of the value of the pre-race data to ATR in determining the economic value of the pre-race data. So we know, in that case, that the data was highly profitable to the purchaser. And the Court of Appeal makes the same point in 281.
Can I just, in 321, I know there's an issue of language in all of this analysis, but in the first sentence, third line, we agree with the CMA position, noted above, it is not part of United Brands that the price benchmark must be set at a level to facilitate competition. I mean, if it was might or will not necessarily be set, but I mean, I don't think United Brands does say it must.
No, but I
suppose you could say then there's the nor does, as an additional reason. Then there's the require.
The test does not prove that the potential benefits are such as to justify and render non-abusive whatever prices, well, but nor does the test require a comparison to be made.
There's a dentist out there doing something. Someone's being taught.
Put in my head.
Yeah.
But if one looks at this in the round at 321, it is a matter of language, but we say that to reject market incentivizing prices as a matter of principle is wrong in law. Have a look at NAP.
Yeah.
To say that competition law is not about facilitation or promotion of competition is equally wrong. Have a look at the Court of Appeal in National Grid. It's not all about promotion of competition, because otherwise, as they say, it could be any price. But it is relevant. If you are, Scheme M is promoting competition, why do they want competition? They want it because they don't want shortages of medicine. So it is relevant. And then to say, well, you don't weigh up the benefits with the price, we say, well, if that is what it is saying, which it looks as that's what it's saying, that is clearly wrong as well. And then it goes on in a couple of lines to agree with an assessment that the CMA never made on the benefits. And again,
Is that convenient? What's the time? We'll start at 2:05.
All rise in favour.